And I do want to make a brief mention before I introduce our speaker and instructor today. Please do visit tskmarketing.com. Kaye Rembaum, A1 Appliance and Refrigeration, Association Reserves, Benjamin Moore and Regal Paints, Best Roofing, and the Water Restoration Group. All vetted, wonderful presenters, and they are the ones that made this presentation complimentary for everybody here today. Okay, so please check out tskmarketing.com. At any time, you could even communicate with our service providers directly from that site as well, sort of a one-stop vetting service for your community associations. So without further ado, I now want to turn it over to Allison Hertz from Kaye Rembaum. And Allison is going to introduce herself, but I do want to say she's one of very few. There aren't many in the state that are board certified specialists in condominium and plan development law. And we have one of them today with Allison Hertz. So Allison, the floor is yours. Take it away. And also, before, I'm sorry, I lied, Allison. This is for condominium association board members. You're all welcome to stay, but the certification today is for new condo board members. And at the end, we'll have an evaluation for you to fill out. We'll put it in the chat and it'll pop up after the webinar ends and appear in an email tomorrow. Now, Allison, it's all yours.
Thank you. Thank you, Jeff. Thanks for that nice introduction. Good to be here. Good to see everybody. I guess we are here for the condo board certification course. If you're a homeowners association member, this is really not the course for you. It will not be pertinent to homeowners association members or board members. You will not receive the proper credit that you need to fulfill your requirement. Once again, happy to be here. Allison Hertz from the Palm Beach Gardens office of Kaye Rembaum. As Jeff mentioned, I'm board certified in condominium and plan development by the Florida Bar. That is a subspecialty designation that you can receive after fulfilling certain requirements, taking an exam to become board certified in condo law. I want to let you know I also work very closely with the Florida Bar in terms of condo legislation. I'm part of the Condo task force on the collapse issue out of Surfside. I'm serving as the reporter for the task force, so I'm privy to the task force and what the objective is there, looking at condominium law and emerging issues resulting from the tragedy. I was also part of the emergency powers task force in light of COVID for the Florida Bar and the hurricane protection subcommittee. So I've worked on a substantial amount of these new issues for condo law in the past couple of years, and I'm here to talk about that throughout the presentation. I will tell you that we have many slides to get through today. This is a 2-hour course, 5:30 to 7:30. I hope to get done before 7:30 if possible, but we have 117 slides to go through. If you've taken a course with me before, I always say that, as there's so much to get through, and I always try to be as detailed as possible, but there is a possible chance that we will not get to the end of this presentation today, and I might jump around through certain slides and fast forward a little bit and focus in on a different area. So there could be some slides at the end where we don't get through. I always try to take questions as we go in the course. So please feel free to include some questions in the chat box. As Jeff mentioned, try to be concise. Don't go through a whole history of facts relating to your association in these questions, and try to keep them pertinent to the slides that we're discussing. After I go through maybe a certain topic in the PowerPoint, then I'll go back to the chat to see if I feel that any of the questions should be taken at that time. And then if we have time at the end of the course, I will also try to take questions. And then finally, if I don't get to your question, I apologize. It's nothing personal, but feel free to email me. My email address is in this PowerPoint. I'm sure it will be part of the information sent around. I know Jeff will send a copy of the PowerPoint to everyone, and it will be included as a link in the chat today. So you can always email me your brief questions as well. And without further ado, let's get started. Why are we here today? Well, we are here today to be on another Zoom meeting, and thankfully we have Zoom. We're also accustomed to it these days, but we're here for the Condominium Board Certification course. This is a course that is required within 90 days after being appointed or elected to the board. You either have to take a course administered by a educational provider approved by the Department of Business and Professional Regulations, such as Kaye Rembaum, with us here today, or you must certify in writing to the association that you've read the association's governing documents. You'll work to uphold the documents to the best of your ability, and you will faithfully discharge your fiduciary responsibility to the association's membership. So it's, in my opinion, obviously a lot better to attend a course, get the information firsthand. We're going to be going over a lot of the new legislation that became effective just this past July 1. So this is the most up-to-date condo board certification course that I think I've done here at Kaye Rembaum. Since that legislation became effective, most of it was July 1. And as we go through this, I will try to hit on those new points of law as we go. So as I mentioned, you have to take this course or sign the certificate within 90 days after being appointed to or elected to the board. And you may attend this course within 1 year before being appointed or elected to the board. You have to have this course one time if you serve without interruption on the board, but as soon as you go off the board and then come back, you would either have to take the course again or sign a certificate. Once again, I always say, take the course again, take another course next month being offered by Kaye Bender. We have many different board certified attorneys here. So even though you take my wonderful course, maybe you want to hear from Andy Black next month or Michael Bender, Jeff Rembaum. That would be great. We also have a legal update course upcoming, which is going to be advertised for the next couple months. Check back our website for this legal update course. If you don't attend one of these board certification courses, or if you fail to sign the certificate, you will be suspended from the board until you complete the requirement. So you don't get permanently removed from the board, but you are temporarily suspended until you fulfill the requirement. And we have some crafty owners that like to ask for official records and try to get a gotcha on certain board members who have inadvertently not taken the course or signed a certificate. So they will come out and try to call you out and tell you you're temporarily suspended. So if you have somebody on your board who has almost hit that 90-day period, let's get them into this course, get them the link, and get them started before we get too ahead of ourselves here. I want to go back here just a minute. It's not in the course. We're going to be talking about a lot of information today. I said 117 pages, and it is slightly overwhelming for particularly those who are new to being on boards. I want to mention that if you are a board member and you act reasonably, and you don't derive improper personal benefits from your service on the board, you don't get kickbacks, you take the advice of experts, you don't act in wanton and willful disregard for the safety of others, you will be protected by the association. The association directors are directors of a not-for-profit corporation, and the corporation is required to somewhat cover you when you work for the association in your capacity as a director. So don't be too concerned about all of these requirements. Yes, you have to comply, but are you going to be personally liable, personally in trouble as a board member for acting in your capacity as a board member? Probably not, unless you commit one of those bad acts, which 99.9% of board members don't do anyway. So I just wanted to get that off my chest before we move forward. We have a lot of laws to talk about. What laws are we talking about here? Well, we're talking about the Florida Condominium Act primarily. That's Chapter 718 Florida statutes. We also talk about Chapter 617 Florida statutes. That is called the Not-for-Profit Corporate Act. So when something is not addressed in the Florida Condominium Act, sometimes we'll look to the corporation statute to fill the gap. Also, don't forget, there's also a Florida Administrative Code which governs condominium operations, budgets, elections, and therefore, once again, if something is not contained in the Condominium Act, it could be supplemented by this administrative code, and particularly on budgetary items and elections and recalls. I will tell you, the Florida Administrative Code does provide some substantial supplements to the act, which are very important. An area that clients ask about all the time and that I talk about all the time are conflicts between governing documents, conflicts in the law. what governs over what supersedes. Well, I like to consider the declaration as the constitution of the community. It is the most important document. It is the highest of authority. And this is where you want to have all of your critical use restrictions. And it is the most enforceable document. The courts have clothed declaration provisions with a presumption of validity, and they will enforce them as long as they're not unconstitutional or arbitrary. Then we drop down to articles of incorporation. Those are the second highest of authority documents. Then we get to bylaws. And as you'll see here, I always say rules and regulations aren't even on this page because we have another section on rules and regulations and their potential downsides. They have to be reasonable, and most critically, they cannot conflict with the provisions of the declaration articles or bylaws. You cannot use your rules to circumvent your other recorded documents. So the point of this is declaration is the highest of authority. It governs. It is where you want your critical restrictions in the event you are thinking about doing amendments to your governing documents, use restrictions, leasing restrictions. The declaration is where you want them to be. There's the most enforceable document. Quickly, we'll touch on managers for this next topic. Let me go to the Q&A a little bit. Okay, nothing pertinent yet. Do we really need a manager? This is the topic. You know, you're not required by law to have a manager or a management company. You are allowed as a board to what's known as self-manage. That doesn't mean that you can hire somebody as your manager and pay them money. That is not self-management. Self-management is when your board of directors runs the corporation on behalf of the membership without payment to a third party for management services. When somebody performs management services for you, they must be licensed when you have an association of more than 10 units, or you have a budget in excess of, that's supposed to say $10,000. So most oftentimes in an association, residential, commercial associations don't require licensed managers under the Community Association Management Statute, but most oftentimes, if you are paying somebody to perform management services, you are going to be within this bucket because you're going to have more than 10 units or a budget in excess of the $10,000 amount. This is a very low threshold for management licensure, I think. Management duties that are authorized, they can calculate votes, they can complete forms for you, drafting meeting notices, preparing estoppel certificates, negotiating payments, coordinating maintenance services, drafting demand letters. These are all tasks that, if performed by an individual for payment, that individual is going to need that manager license, and you would not be in good shape to employ somebody otherwise. Sometimes clients ask if they can have an administrative assistant work in the office without having a management license. Yes, of course, you can have an admin, but you have to be very careful in terms of what that admin does so it doesn't go above the line performing the management services. The board is the one who does all of that and has the admin really work in the office performing ministerial duties for the board members who are really the persons who are performing the management functions. So I caution you in being very careful with that and ensuring that anybody who you pay for management services is licensed by the DBPR. Moving on to a different topic, which we talk about a lot here, transfer fees and estoppels. This comes up all the time in daily practice. Clients ask about these issues all the time. Transfer fees are generally disfavored by the state of Florida. This statute, it's a real estate statute, 689.28, actually provides that transfer fee covenants violate public policy. So why do we charge them for condominiums? Well, we actually have a carve out for condo associations. A fee, charge, assessment, or transfer fees charged by a condominium association, here we have in the bullet point number 1, are not prohibited transfer fees under this real estate statute. Red flag area here, this is a law that just was changed this past July 1. if you have regarding transfer fees for condominium associations. But let's talk about that. Can you just charge a transfer fee inherently? Does every association have the right to charge a fee for a transfer, a screening and background fee? No, the answer is no. The charge is not, you have no inherent authority to charge this fee, and you have no inherent authority to screen and approve transfers. Screening and approval of transfers has to be authorized by your declaration. So if you see this first bullet point, this is like a two-step analysis. A condominium association cannot charge a fee, it's actually a typo here, unless you have the right to approve the transfer and you have the right to charge the fee. So it's a two-step analysis. Number one, do you have the right to approve the transfer, whether it's a sale, lease, other type of transfer title, gift, some other type. So first you have to analyze whether you have the authority to approve that transfer. And then second, you have to analyze whether your documents give you the authority to charge the fee. If it's yes and yes, the fee cannot exceed $150 per applicant. The fee prior to July 1 was $100, and it was $100 for the entire time I've been practicing condo law, which is 15 years. So we have now finally, this many years later, increased the fee by $50. Keep in mind, the $150 is per applicant, but spouses are considered one applicant. So you can only charge a couple $150 for that, for the two people. The 150 is new. Also, what's new is that every 5 years after July 1, 2021, the transfer fee will increase according to CPI. So by 2026, we will see this fee trickle up a little bit. We'll see maybe $152 you'll be authorized to charge. We'll see. You are not allowed to charge the fee for the renewal of a lease with the same tenant. If you have a smart attorney, like us here at Kaye Bender Rembaum, you will likely have some document amendments, maybe go do some lease amendments, where what I do is I say that each lease is a new lease subject to approval of the board and subject to a transfer fee. There are no renewals of leases, and that simply doesn't apply. Other fees that can be charged. Well, this is actually not a fee, it's a deposit. Security deposits. This is one where it's not a two-step analysis, it's actually a one-step analysis. You don't have to first have the authority to review and approve the transfer in order to charge the security deposit. This is just a flat authority if contained within your declaration articles or bylaws. So despite whether you have the authority, you might not have the authority to screen and approve people, but you might have the ability to get the security deposit not to exceed 1 month's rent. Keep in mind, this is somewhat administratively burdensome because you have to keep these deposits in escrow accounts in the same manner as you would for a landlord-tenant deposit. So I think it is advisable and beneficial to get the deposits in the event you have the ability under your governing documents, but this is a case where having professional management or a manager and not being self-managed probably would come in handy, where the manager and the company could administer these deposits for you, making sure they're in the right account, making sure they're returned properly, and that everything's taken care of. But have this authority if in your articles, bylaws, or declaration, of course. Moving to a completely different circumstance, we're talking about estoppels, estoppel certificates. What is an estoppel? Well, estoppel used to be a document requested by a buyer, somebody in the chain, the title company, refinancing, somebody in those chains, I'll say, and they want to know how much is owed on the unit. Is this unit delinquent? That's what an estoppel used to be. And the association would write back and say how much is due, and that is a document that requester could rely on to then make a decision concerning whether they want to move forward with the transaction. So here, as of a couple of years ago, the estoppels have been changed, and now we have much more information that is required to be provided in connection with an estoppel. We have to, in addition to the delinquency information, we have to give, parking or garage space number. We have to give the assessment information, obviously. We have to give whether there's a transfer fee provided in the documents, that's number one. We have to note on the estoppel whether there's any open rule or regulation, open violation of a rule and regulation. We have to provide whether there's a right of first refusal to the members. So there's a lot more information other than delinquency information that has to be provided on those forms at this point. I try not to harp on this too much, but it's hard not to because this is so important. I mentioned that this is a document that a buyer can rely on. So let's just go back to this. I just like to highlight a few different things that could be pitfalls here. Parking or garage space number. That's very important for condo associations. There's been many disputes over parking and garage space numbers. I thought I had parking space 5. Now you're telling me I have parking space 15. 15 is not as good as 5. What's going on? Well, if you place a number on this estoppel form, such as 5, parking space number 5, and then when the owner gets to the unit 2 months later after closing and they move in and you tell them, oh, actually, you don't have space 5, you have space 15, that owner has a pretty good argument showing you the document and saying, you know, right here on this estoppel form, you put that I have parking space number 5 and I can rely on this estoppel form and I feel that this is correct and that I should be given parking space number 5 and not 15. So that owner would have a pretty good argument against the association. So you have to get this information right. That's the point I'm trying to make. I will also note that this is one that is somewhat of a pitfall. Whether there's any open violation of a rule or regulation previously given to the owner of the unit. If you had a condo where the prior owner happened to paint the door pink and you sent out a violation letter saying that door is improperly, you improperly changed the door, it doesn't conform to the other doors anymore, you were demanding that you paint this door black in order to conform to all of the other doors in the condominium. So in the midst of all this, there's a new buyer. The buyer requests the estoppel, and it's not noted on the estoppel form that you previously sent this demand letter saying, paint the door black. That's a violation. Your door is pink. You cannot have a pink door. So the new owner comes along and buys the unit, closes, moves in, and then gets a letter saying your unit is in violation, the door is pink, please turn it back to black. And the owner would then say, you know, I don't understand this. I had an estoppel when there's this question saying, is there an open violation? And their association put no. So that's a pretty good argument for that owner that there was no violation at the time they bought the unit, and therefore they can continue to have a pink door. So I'm showing you where these things go. Obviously, the most critical problem with this estoppel is if you put the wrong amount of delinquent assessment on the form. If this unit owes $10,000 and you by chance leave out a 0 and you indicate on the form that they owe $1,000, okay, don't bury your head in the sand. You have another chance. If the sale or transaction has not closed, you have another chance to amend the estoppel before that occurs, not at their cost, on your own dime. You have to send them an amended estoppel right away, showing the mistake, saying, hey, there's an amended estoppel. Your delinquent amount is not $1,000, it's $10,000. And if you get it out there before the transaction closes, you should be okay. If you get it out there late where the transaction has already closed, they will be able to rely on the document reflecting that they only need to pay $1,000 rather than $10,000. And that is going to be a problem for somebody. I know somebody made a mistake, and that's going to be a problem for somebody. Let me quickly check these questions to see if we have anything that we want to answer. Background and fees, are they limited to 150 for both? Well, background transfer fees are kind of the same thing. If you're going to do a background search, an application fee, you know, whatever you're going to charge in connection with the transfer is limited to that $150. The estoppel fee, actually, we're about to talk about right now, and those are separate. You can charge a fee of not to exceed $250 for the estoppel, And you can charge an extra $150 if the unit is delinquent, and you can charge an extra $100 if they want to rush. So it's $150 for the transfer application background fee, which is one fee, and then a separate fee for the estoppel, which is typically going to be $250 if they're not delinquent, and an extra $150 if they are delinquent. So there are a lot of fees just to even determine whether you want to get into the condo. Before you even get in, you're paying quite a lot of fees to sort of do your due diligence and determine whether this is something you really want to do. Can you get reimbursed with an estoppel? Yes, those $250 charges and $150 for the delinquency, you can be reimbursed for those fees that you pay if your transaction never closes. You have to request that the association reimburse you, and then the association can actually charge the owner of the unit the same amount. So while you might have to pay back the requester, which could be the buyer, somebody in the chain of title, then you can then recharge that to the current owner who was part of the transaction. We also will have the increase of estoppel fees based on CPI, and we might see that shortly, because I feel that the initial estoppel legislation was from 2007. So we will see the increase for the estoppel either this year or next year. But once again, it will be very slight because it's according to CPI. So I feel that this will be a couple dollars, not hundreds of dollars, that's for sure. There's also an effort, I believe, by many different groups, possibly realtor groups, to curb the estoppel fees. They already believe the fees to get into a condo, as I mentioned, to even evaluate whether you want to be in a condo, are quite high. So there's always different industry advocacy groups who have an interest in keeping these fees not so high, I will say. The estoppel document that I just talked so much about is good for 30 days, right? If the transaction doesn't close within that 30-day period, they're going to have to ask for another one. They will have to ask for another one, and they'll have to pay the money for another one. Sometimes in the transaction process, you'll be asked for other information, some information about ongoing litigation. Maybe there's an open case in your community. Maybe the buyer or some person in the chain needs more information concerning the level of reserves that you might maintain at the condo. None of this is really required to be provided to a third party. While we all know, I would believe, that you have an obligation to allow members and their authorized representatives to access official records, third-party buyers, third-party mortgage companies, third-party lenders, third-party closers in the title company, they're not entitled to get extra information from the association. While they're quite aggressive sometimes and assert and contend that it's required by law that you respond to them within 5 minutes and provide them with all access to everything that they would demand, I would take a good look at those requests, because sometimes giving too much information can impair the interests of the association. While you don't want to, not be forthcoming when it makes sense, disclosing too much information could just not be in the interest of the association. Plus, it might take up some time and be administratively burdensome for you. So in the event you would like to request additional funds to take care of those requests, that is authorized in law. If you have a mortgage company coming to you asking for a description of ongoing litigation in your condo, you can charge them a fee not to exceed $150, and you can actually charge them your actual attorney's fees in connection with the request. So some associations just like to handle this on their own. They say, you know what, everybody's going to be in this situation sometimes where they're selling, so let's just deal with these in-house and somehow try to like help facilitate the transfer and be forthcoming and really try to move this along for the member. And some associations get hesitant about doing that. They don't want to say too much and then have an action and have somebody point the finger at them. So they might request that my office handle these, and they say, Allison, you know what? You handle this description of the litigation. You ask for the money up front. You know, if you think it's going to cost $300 to respond to this thing, we ask the company to send us the money in advance, and we get the payment in. Then we issue our letter responding to whatever they need. And the association doesn't really have to act as the middleman or feel that they're putting themselves out there and saying too much. You can say, Allison, we just want you to handle it, and you just do your thing. I will say that the last bullet point on this slide is very important. You might want to star this slide or remember the page number and come back to it at a later time, 23, slide 23. If you do fill out these forms or provide litigation updates for your association, whether you're a manager or a board member, you can include some disclosure language that might kind of limit your risk in providing these things. So it says the responses herein are made in good faith and to the best of my ability as to their accuracy. So this other requested information is not part of the estoppel. They don't get to rely on it to their detriment because it's not required to be provided. And you're putting this disclosure statement on it to say it's to the best of your ability, and it, you know, might not be 100%. So if you're going to respond to these kind of requests on your own, I would strongly, strongly recommend that you go back to this page and that you include this disclaimer, I guess. So that's what I would call it, not a disclosure. It's a disclaimer with your responses. Other documents in the transaction, sometimes you might have somebody ask you for the FAQ, the frequently asked questions sheet. That is part of what you might be requested to provide to a buyer. You can charge $150 for the FAQ unless the buyer or the party requesting it is on site in your association office. Documents, people who come to your association, if you even have an office, well, the law, I think, is really stuck in time, because you'll see the second bullet point on the slide says the association has to maintain the governing documents as well as the year-end financial information and the FAQ, and it has to make those documents available to owners and prospective purchasers on site, and may charge its actual costs for furnishing and preparing these documents. So if somebody comes to your office, knocks on your door and says, can I please have a copy of the declaration, articles and bylaws, the rules, the year-end financial report, and the FAQ, you are required to provide it. You may not charge $150, but you may charge your actual costs for preparing the copies that you need to give to them. Of course, in this transaction, the buyer really should be getting this information from the seller. The seller, the unit owner who is there, the member of your association, has a full right of access to all of your official records. So if I was a buyer, I would try to maybe work with the seller to see what information I can get. And sellers do have to provide disclosures to the buyer. They have to provide the declaration, articles, and bylaws unless they waive the right to get them. They should be providing rules, financial information, and the FAQ. So the seller is required to provide that to its buyer, but a lot of the times the buyers come directly to the association. Associations don't have any what is known as privity with these buyers. They have no relationship to these buyers. They're third parties off the street. So we really have no duty to them to give them any of these documents direct unless they're on site in the association office and we're under this bullet point number 2. All right, let's get off of this topic for now, and I will check the questions. Let's see. Are capital contribution fees allowed? I recently heard they were not. From Diane. Capital contribution fees are allowed in a homeowners association if authorized by your document in a homeowners association. Capital contribution fees are not allowed in condos. You may have asked that because the estoppel form language in the Condo Act actually has a reference to a capital contribution, but they are not allowed, and they would be an improper transfer fee. All right. The estoppel fee is charged to the buyer, Jean. That was a question from Jean. Jean Malloy, it's charged to the buyer or the person who requests it. If they don't close and they ask for the reimbursement, then you have to reimburse them and then you get to charge the owner. So it just kind of depends on what's going on over there. All right, back to the presentation for now. Membership meetings. Every year you have to have an annual membership meeting. I have some associations who say, well, everything is great in our condo and the board's just going to be elected again, and we had COVID last year and we had some personal issues going on and somebody moved, and they have 100 excuses why they don't want to have an annual membership meeting. But it's called an annual membership meeting for a reason. It has to occur every single year, whether you're electing a board or not. You must go through the motions of noticing and holding an annual membership meeting. Sometimes during the year, you might have a special membership meeting. You might have a special membership meeting when you're possibly taking a vote to reduce reserve contributions, when you're taking a vote maybe on a material alteration to your common elements, maybe when you're amending your governing documents. So that might be some special meeting throughout the year that's not held in conjunction with your annual meeting. And members of your association can petition for a special membership meeting with 10% of the unit owners. I don't see that occurring very often, but I have seen it before. Maybe an owner wants to propose their own amendment to a document. They want to, frankly, just have a meeting where everyone has to get together to hear somebody out on a special issue. So it does happen if you get a petition for a membership meeting from or on behalf of some of your owners. Don't throw it in the garbage. It is serious. And it would be required that the association notice and hold that meeting if they meet the threshold. Membership meeting, the notice has to be provided 14 days in advance. This is one where you're going to have to mail or hand deliver or electronically transmit with the consent of the owner. The notice, you also have to post it on the property 14 days in advance. We have a lot of associations who get so hopped up during the election season about sending out the second notice of the annual meeting and election 14 days in advance that they forget to post that second notice on the property. That's critical. It's required. Don't forget to post it on the property 14 days in advance, in addition to mailing or emailing with the consent of the owner. Similarly, website requirements. We'll get to that later, but a condominium with 150 units or more must have a website, and certain information must be posted to the website from time to time. Notice of membership meetings must be posted to the website. So in addition to mailing or emailing with the consent of the owner, posting on the property, you also have to post on this website if you have 150 or more units. You can waive notice of meetings. In certain associations, you might post your notice on a closed circuit television channel. So there's other supplementary or additional ways to post the notice, but the critical is either mailing or emailing with the consent of the owner and posting on the property. At every membership meeting, you're going to want to execute an affidavit of mailing and posting, basically to keep in your records. It's required. Whoever performed the mailing must say, hey, by the way, I did send this out on this date and this time, and it was 14 days in advance. I've been saying during that entire slide that you could email notices. Well, the law was changed many years ago now to say that notwithstanding what your bylaws say about the manner in which notice must be provided, if an owner consents in writing to receive notice via email instead of mail, that is okay. So I would strongly suggest that you roll this out if you have not done so already. Many associations are saving a lot of money on mail and are having better responses from their owners with email notices. So when you have a new owner come in, if you've already rolled this out and you have many, if not all of your owners receiving notice via email, you might have this sort of as your standard practice and protocol with any new owner that comes to your community. Part of your your new owner package, you include the form that authorizes them to receive the notice via email. It's much easier. I will say one thing, that when you give your email address as an owner to receive the notice in this manner, that allows other owners to access your email address. So now your email address became part of the official records. So if you don't want every owner in your community getting a hold of the email address that you use all the time, you may consider creating an alternative email address to use for this purpose only. I would recommend now putting on your owner hat, not necessarily your board or manager hat, but as an owner, maybe you don't want your email address out there floating around because you'll get inundated with emails depending on your association. So what happens at membership meetings? Well, membership meetings are about the members. It's funny because a lot of times I get a question, we don't have a quorum of the board at the annual membership meeting. Are we going to be able to move forward? Well, yes, of course. No, you don't need a quorum of the board at a membership meeting. You only need a quorum of the board at a board meeting. So for a membership meeting, you typically need a quorum of the membership, and that's going to be provided in the bylaws. Typically, it's going to be a majority of the total voting interest. And decisions such as waiver of reserves, waiver of financial reporting, those are all going to be based on a majority of the quorum. Votes regarding amendments, material alterations, those are typically not a majority of a quorum. Those are whatever your document provides for that vote, which most oftentimes is something higher than a majority of a quorum. Participation in membership meetings, again, this is a membership meeting, so obviously members get to participate. And the rules of participation, so I don't go over this twice, are the same for membership meetings and board meetings. So let's just go over these. Unit owners have the right to participate in meetings with regard to all agenda items. They can speak on every agenda item if they want. So sometimes I advise my client to maybe limit agenda items, combine agenda items into, rather than having 10 bullet points, maybe we try to get 5. So that person who wants to speak on every single item and really doesn't have a lot of good things to say is limited. You are allowed to adopt reasonable rules regarding the frequency, duration, and manner of unit owner participation. So if you want to have a sign-up sheet at the front of your room where you hold the meetings, to say, hey, if you want to speak on an agenda item, you have to sign up on the list. That keeps an orderly meeting. Of course, we can have sort of a 3-minute limit. That's the standard that we all see. You can only speak for 3 minutes. And the manner of the participation, we have rules of decorum in a lot of associations where we say, everyone has to be respectful, no yelling, only one person at a time when recognized by the chair. So these are the type of rules that you might think about adopting in your association, particularly if you have unruly members and you want to try to get back on track. You have to enforce these rules. They don't enforce themselves. I don't recommend getting into a shouting match and getting in someone's face to enforce these rules. But it's good to have a start where everybody knows what the guidelines are, what everyone expects, how everyone expects the members and the board members to behave. And so I would recommend that you think about adopting some of these rules because they are very helpful to many associations. The third bullet point on this page is very interesting. People get very upset about this. A unit owner may record or videotape a meeting of the unit owners subject to reasonable rules adopted by the division. So unit owners are permitted to videotape and audio tape board meetings and unit owner meetings. The only rules that you can impose for videotaping are very few. They're set forth in the Florida Administrative Code. And the main rule that is authorized is that you can require somebody to announce themselves at the beginning of the meeting saying that they're taping. So if you don't have that rule, I would recommend that you think about imposing a rule that before you start audio video taping, you have to announce yourself. Some people find this rule completely inappropriate because they might know that here in Florida, we have what's known as a two-party consent state. So in order for somebody to typically record audio here in Florida, you need somebody's permission. Well, this is an exception to the rule. This is an exception to that general rule that if you go to a condo meeting and you are there, the Florida statute says this, that you have basically implicitly consented to being recorded at that meeting. And this applies once again to membership meetings and board meetings. I see some questions here. Some of them are a little specific, and then we have an election question, and we're getting there shortly. Voting at membership meetings. Voting is generally in person or by proxy. There are two separate kinds of proxies, a general proxy and a limited proxy. In condominium law, we are not allowed to vote by general proxy. That is what I call, it's just a, well, let's do limited first. Limited proxy is what's known as a directed proxy. So you're signing a proxy telling somebody else exactly how to cast your vote. A general proxy, you're giving that person discretion to vote however they want for you. So again, in condominium law, we only use general proxies for quorum purposes. You can designate somebody as your representative to show up at the meeting to establish a quorum, but they cannot vote in their discretion on that reserve vote, that amendment, the financial report. So they would have to submit a limited proxy to vote in a specific manner. All proxies are good for 90 days from the original meeting for which they were given. So I like to give this example for an amendment. If you have an amendment that you're really trying to get passed, you want to say, no trucks. We'll just use that example. No trucks. This is very important to you. We do not want them anymore for whatever reason. And your meeting is going to be September 1st, right? But you've already realized that you are probably not going to get the vote that you need because a lot of people are out of town and school just started and the COVID resurgence is difficult and people aren't moving around. And you think, you know what, we're going to need more time. You know what, these proxies are good for 90 days. So what I would recommend in that case is that on September 1st, you do not take that vote. You go to the meeting and you say, you know what, we're going to adjourn to continue this meeting for up to 90 days to give more people the opportunity to vote. You check your bylaws. You might have to consult your counsel concerning whether an additional notice would be required for the reconvened meeting, but then you're able to add proxies to the proxies that you've already had. So the proxies that you've received already stay good for the 90 days. Maybe you only need 30, so you reset the meeting October 1, but it gives a chance to add proxies to the vote so you don't then have to send out the entire package over again and start from square one. That is a process. If you would like to try it, I would recommend that you consult with counsel to make sure that you're jumping through these hoops properly. Particularly if it's a very important amendment or vote, because you want to be able to connect the dots and not have somebody be able to poke holes in your vote and make it illegitimate. Election of directors. We had a question here concerning whether you need a quorum of the owners to hold an election of directors, and I'll just answer that now. The answer to that question is no. You only need 20% of the eligible members to cast a ballot in order to hold an election. And the election is actually the first item of business at your annual meeting. So before you even establish a quorum, a regular quorum, you do the entire election. And then once the election part of the meeting is completed, then you get into the regular business of approving minutes and taking any other action that you may have had on the agenda. So no, a traditional quorum is not required for elections. Only 20% of the eligible voters have to cast a ballot. Okay, getting into the election, let's take a deeper look at the election. How many directors are serving? This actually gets kind of complicated sometimes. Your governing documents really should set forth this with specificity. If you are confused concerning the number of directors who should be serving, you need to talk to your lawyer about it. Sometimes it's not as easy as one may seem. In condo law, you might see a range. You might see between 3 and 9 members as determined from time to time, well, that might be okay. Between 3 and 9 members as determined on the date of the election, that's not good. We have to send out ballots in advance of the election, so we can't determine the number on the day of the election. So actually the case law says that with that type of bylaw language, where there's a range and the number is determined at the election, well, that doesn't provide for a number. So in that situation, it would default to 5 members. So as I mentioned, the number of directors could get a little tricky. It is supposed to be set forth in your documents, and this is an area that is ripe for an amendment if you frankly have a provision that's not well written, it's old, it provides for one of those ranges that's difficult to work with, or if you simply don't like the number. Maybe you have a document that says you have 3 board members and you think 5 would be better. Maybe you have a document that says you're supposed to have 7 board members and you would rather have 3. So it's really not a one size fits all here. It's what serves your community the best. And that's different for each association. So this is an area where you might want to think about an amendment to get the number of board members where you want them and to get them serving the terms that you want. The default term for a condo director is a 1-year term, but governing documents can provide for longer terms. They can have 2-year terms, we can have 3-year terms, we can have 2-year staggered terms where every other year, maybe 2 or 3 directors are elected for 2-year terms. I tend to like 2-year terms or 2-year staggered terms because I think it provides a lot of continuity on the board. I know many board members, many boards, associations get, bad raps for not being able to get projects done quickly, and that maintenance isn't the way that the owners feel that it should be going, or, you had a project and it's taking too long. Well, board members, a lot of the times only serve 1 year, and it's very difficult for any board to get anything done in 1 year. By the time they, investigate it, vet it, bid out a project, it's already almost to the end of your term, and you have to negotiate a contract, go back and forth with the attorneys. So when you have large projects on the horizon, these 1-year terms are very difficult to work with. So I will stop harping on this, and I will just tell you this is an area that you might want to look at to provide your board with 2-year staggered terms so that every other year you have people staying on the board to help those new members continue the business that was remaining from the last term. In 2018, the statute was amended, the Condo Act, of course, to provide that a director cannot serve more than 8 consecutive years unless 2/3 of the owners vote for them in the election or there's no one else willing to serve. And for a while, there was some talk about whether this was retroactive or prospective. And finally, just this year, just 2021, the statute was amended to put crystal clear language in that the term limit is prospective as of July 18. So those 8 years would start running in 2018. We're not there yet. We haven't seen this really come into play. And there are loopholes here. It's consecutive years. If you resign for 2 days, I think that's not a consecutive year. Plus, I mentioned if 2/3 of the owners vote you in, then you're in no matter what. So, there's some workaround here. There's always maneuvering in condo elections, as you know. Sometimes it's more benign than other times. And this is one that is somewhat ripe for maneuvering, but at least we now know we have the statute change that it is prospective from 18 onward. From time to time, you might have vacancies on your board where somebody might move out of the building. You might have a death, unfortunately, and the law provides that unless otherwise provided in your documents, the current board is going to fill the replacement for the balance of the term. So if you had a 2-year term where somebody maybe resigned in month 1 of their 2-year term, the then current board would be able to select the replacement to serve out the balance of the 2-year term. Board member eligibility, we get into this quite a lot nearing election season. I will mention that the statute, the Florida Condominium Act, is the law on eligibility. Your documents cannot provide for additional eligibility requirements, such as you can't live, I see these things, you're not eligible for the board unless you live in the building 6 months a year, or you're not eligible for the board, or you get kicked off the board if you miss 3 meetings. None of that is valid, in my opinion. The case law does not support that. The only thing that it supports is that the governing documents can restrict board members to be unit owners. So you definitely can have a document that says only unit owners can be board members. Sometimes it won't be like that from the beginning, and you won't even know it. And then you'll get into, your condo's been in existence for 20 years and Mary Smith's been on the board for 5 years. She's the spouse of an owner, and you just found out that your document said board members have to be owners. This is something that needs to be looked at prior to your election. You want to get it right here. This is not that difficult to determine, so it's something that you want to look into. A lot of associations also want amendments to require that board members be unit owners, because maybe they had a document from a long time ago where they don't want somebody's spouse who's not on the deed to be on the board. They don't want somebody's cousin who's not on the deed. They don't want somebody's lawyer, frankly, to be on the board, acting as a board member for an owner who's absent, something like that. The statute otherwise provides that you cannot be on the board if you're a convicted felon who hasn't had their rights restored for at least 5 years as of the date you seek election. You cannot be eligible for the board if the Division of Florida Condominiums has suspended or removed you, which makes sense. This is the critical one. This is a star page, new law change as of this year. As of July 1, a person who is delinquent in the payment of an assessment due to the association is not eligible to be a candidate. This is a very slight but important change. As you'll see here, I struck the language monetary obligation. The statute was just amended to remove that language. So now, so previously, prior to July 1, if you were delinquent in a fine, if you were delinquent in some kind of lost key card fee, extra parking space fee, some other charge that the association makes to you, that is not a basis for precluding you from being on the board. Only assessments are considered now. So this is a very up-to-date change. Star this page if you've been on your board for a long time, and this is the latest and greatest change. So going into this next election season, keep this in mind. We'll have to change all of our election forms. The notice of intent form that typically has the eligibility requirements on it will need to be changed. If you do that in-house, make sure that you keep track of this. I will be presenting a course, I think in the next couple months, maybe next month, October, I believe, on election issues. I love presenting that course. I tend to like a lot of these election issues, and it'll be more in depth on elections, so look out for that. Finally, number 5 on this page, in a residential condominium association, co-owners of a unit cannot serve on the board at the same time unless they own more than 1 unit. And this is just a little bit tricky. This is not about eligibility to be on the ballot. This is actually about service. So if co-owners nominate themselves, they can get on the ballot, but they can't serve at the same time in a certain situation. So this is a little bit more tricky. This is one where you might have to bring this to the attention of your corporate counsel and have them guide you a little bit on it. Eligibility means that they've met the requirement the last day that they're able to submit their notice of intent. So the end of that 40-day period, you have to submit your notice of intent to be a candidate no more than 40 days before the annual meeting date. That is the critical date where they have to qualify. So if they were delinquent in an assessment, they have to become current prior to that 40-day, or else they would not be eligible to be on the ballot. Let me check the questions just really quickly. Let's see. Special assess, does the eligibility requirement on assessments include special assessments? Rebecca Danner, yes, I believe it would. Can the spouse of the owner run for the board when bylaws say only owners can run? No, if the bylaws provide that it's only owners, that's legit. That's a legit restriction. And no, they cannot be on the ballot or on the board. Let's see. If a board member resigns midterm, how are they replaced? Well, the remainder of the board is going to appoint a replacement. That's going to be done at a properly noticed board meeting. And I think we get into that in more detail as we get into the program. Can an election be held if quorum at the annual members meeting is not met? Yep, we talked about that. The election part of the meeting only requires 20% of the ballots. Okay, so let's talk more about the election. We'll go through this pretty quickly. I feel that a lot of people know this. No less than 60 days before the date of the election, you will receive a first notice of annual meeting. That has to actually just set forth the manner in which you can qualify for the board, where to submit your notice of intent form, and the date and time of the meeting. So this is a very brief notice. It's not a big deal. It's like a one-page notice where you tell them date and time of the meeting and how they can mail their notice of intent back to qualify to be a candidate on the ballot. Or we talked about this, not less than 40 days before a scheduled election, you are required to submit your notice of intent to be on the board. Don't make the mistake as a current board member, for all you current board members out there, don't make the mistake of forgetting to submit your notice of intent. Some current board members think that they're like automatically placed on the ballot as an incumbent board member. No, you have to submit a notice of intent every time your term is coming to an end. So don't forget, or else you will not be able to be on the ballot. If you forget to submit that notice of intent on the 40th day, that's on you. I mean, there's many cases that say you have to assure delivery, make sure you send the notice of intent by certified mail. Don't slip it under somebody's door and expect them to, say that they received it on that last day. So really keep that in mind. 35 days before the date of the election, you can submit what's known as a candidate information sheet. That is where you can set forth your platform and describe why you would be the best board member for this community on a one-page piece of paper. The association's not permitted to redact or edit this document. So a lot of times my current board is somewhat attacked or, critiqued in the information sheet. And that's sort of politics. That's the politics of condo law, where you can't edit it, you got to send it out. No less than 14 days before the date of the annual meeting, you must send what's known as the second notice of meeting. And maybe you'll have an election and maybe you won't. If the same number of candidates submit a notice of intent as there are vacancies, then you don't need an election. That's going to be an election by acclamation. There were 3 candidates for 3 seats. Therefore, we will not have an election, but we still have to go through the motions of doing the annual meeting, approving the minutes, talking about any action that was remaining from last year, giving an update, giving reports of officers, maybe committees, whatever you choose to do, but don't blow it off. Election notices in big red bold text right here. The annual meeting notices and all of the forms must be posted on your website if you have a condominium of 150 or more units. Don't forget about this website requirement. I keep trying to throw it in through the presentation just to emphasize that this is a requirement if you're in this bucket of 150 or more units. We have this slide that I think I've talked about 3 times at this point, which is there's no quorum requirement for an election. However, at least 20% of the eligible voters must cast a ballot. If your association has picked up a title to units, you own units in the association name because possibly you foreclosed for delinquent assessments, you cannot vote those units. The association, the board doesn't get to fill out a ballot for 10 units that it owns. Those are actually not part of the vote here. Keep that in mind. Elections are decided by a plurality of the ballots cast. That means whoever gets the most votes wins. Nobody can have somebody else fill out their ballot. I've seen candidates try to go around with pre-printed checked ballots and then fold them up into the double envelopes and have an owner sign just the outside. That's not proper. Each owner needs to mark on their own how they want to cast their election ballot. You cannot have pre-printed check marks on these ballots, in my opinion. Very important here on bullet number 5 on this slide. This was put into place quite a while ago now, but I think it's a good change to the condo law. Any challenge to the election process, any petition for arbitration or lawsuit that's filed must be commenced within 60 days after the election results are announced. You only have basically 2 months to challenge an election, which is fair because you can't be like 7 months into the year of being elected and then now all of a sudden somebody's trying to get you out and you're about to hold another election. That really doesn't make sense. So they put a very short window on this election challenge, which has worked out quite well. Then you have some certainty, right? So the first thing that is going to occur at the annual meeting is you're going to designate an impartial committee. This is where you have an election, by the way, to be the ones handling the ballots, that they're going to check the ballots off against a list of authorized voters to make sure that each ballot was filled out by somebody that actually was authorized to vote. So they'll look at the ballot, they say, Mary Smith, Unit 101. Okay, they compare it to the roster. Yes, Mary Smith, she is the owner of Unit 101. Check mark, she submitted the ballot, put it off to the side. So that's how you check in ballots. The committee who does this cannot be a current member of the board, cannot be an officer, cannot be a candidate for the board, and none of their spouses can act on this impartial election committee. And I would recommend that you choose these people in advance if possible. Sometimes we just get to a meeting and say, hey, who wants to do this? Raise your hand, and that works out. But if you have a very large number of units and a very substantial amount of ballots that come in, you might want to handle that committee process at a prior meeting. This process, the check-in, must be done as the first item on sort of the agenda at the meeting that day, or it could be done earlier in the day, just that day, not earlier in the week, not earlier in the month, at a committee meeting. But this committee meeting has to be open and it has to be noticed in the same manner as a board meeting, i.e. it has to be open to the owners. They should be able to view the committee who is checking in the ballots and sort of watch over their shoulders with masks on maybe to make sure that they're handling the ballots and not improperly rejecting, or, it's an open sunshine type deal here in condo law. So everything is very open. And if you want to come watch the committee check in the ballots, you should be able to. If the committee finds that an unauthorized person signs a ballot, that, this ballot was signed by Ryan Sunshine and the unit is not, Unit 102, and on our records, we have it owned by, Bob Brown. The records just don't match up. This Ryan is not an authorized voter. So you would write disregarded on that envelope and you would put it to the side. You don't open it, you don't throw it away. These are all part of your records that must be kept for 1 year. Once all of the envelopes are checked in, then you start getting into opening the envelopes. And I think we have another slide on that. Now we're talking about electronic voting, but the first step in the opening is that you first remove the inner envelope from the outer envelope. These are 2 envelope systems. You put the outer envelope to the side, and then once you're finished opening all of the inner, to take the inner envelopes out, then you finally can start opening the inner envelopes and taking out the ballots, making sure that somebody didn't submit 2 ballots instead of 1. If they did, it gets disregarded. So that's the general process. Once you've finally taken the ballot out of the inner envelope, then you can start tabulating the votes and creating your calculations as to those who were the winners. A couple of years ago, the statute was amended to provide for an option where you can have electronic voting. That is not, a Zoom meeting. That's not like how we are here today. Electronic voting is using a voting software platform that basically somebody could click a little box instead of submitting a paper ballot. In order to establish online electronic voting, you have to go through a process. You have to adopt a resolution. You have to send the owners notice that, hey, this online voting, electronic voting is available. Please opt in. Give them a certain time frame to do so. If you do establish this, you must send the option to opt in with your first notice of annual meeting. That's also a requirement. So I'm not going to go into too much detail here. If this is something that you think you would benefit from, please re-review these slides, talk to your attorney about this. You do have to jump through some hoops to set this up. You need to work with a vendor who actually has the software, but I do know from working with clients who have adopted this, it is beneficial. You save mailing, you have more participation. It's frankly easier that you don't have to tabulate hundreds of votes. If you have a community of hundreds or thousands of units, and you even have 20% of the owners voting electronically, that is huge. You don't have to sit there and really count those hash marks as we do late into the night sometimes. So this could be quite helpful. I'm going to kind of breeze by that a little bit. Filling vacancies, we had a couple questions already about that. If you have a vacancy in midstream, the remaining board members can fill it unless otherwise provided by your documents. So if you have a 5-member board and 4 people resign and you have 1 board member left, typically speaking, that 1 board member is going to be allowed to select the remaining 4 members. Again, you have to have a board meeting at which this occurs with filling vacancies or replacement of vacant seats on the agenda. You don't just like pick them and go on. You want to paper your file and follow the bouncing ball so people know how these new people got on the board. So definitely have your board meeting. If the board is sort of like in a deadlock, we see this sometimes, maybe you have a 5-member board and you had 1 vacancy and you keep having a 2-2, you cannot select a replacement and it's making life difficult. Maybe you choose to put that out for a special election. So that could be something that you choose to do instead. And maybe your documents require you to do that. There's some very unique bylaws out there. And as I mentioned, this is something that's the default is that the remaining directors get to do it, but if your bylaws provide for some other method, then you have to follow that method. Officers are going to be typically elected at the board's organizational meeting following the election. That is at a board meeting. It's at an open meeting. This is not some special executive session where we get to have a closed meeting, no owners in attendance, and elect ourselves as president, vice president, secretary, treasurer. There's a common misperception I see here, and that this is the only time where the board is allowed to have a secret vote, meaning that they don't have to announce their vote, at the meeting. That doesn't mean that the meeting is a secret meeting or a closed meeting. It just means that they can possibly write down on a little piece of paper who they want to elect as president rather than say it verbally. So don't fall into that pitfall of rushing into a little back room and electing officers in secret. That's not the meaning of the statute. Okay, now getting to our board of directors section, I'm going to take a quick look at this, at the questions. Must a condominium board announce the vacancy or a unit for sale? I think this is like a right of first refusal type issue. That's not pertinent to this course. I'm sorry. We can talk about that at a later time or via email if we have a chance. In case of a lost ballot or mistake, a new ballot would have to be issued by the association. I think they're talking about here can you get another ballot from the association? Yeah, my thinking is that yes, you cannot submit more than one ballot, but if you feel that you misplaced the ballot that was sent to you, you should be able to receive another one. And blank ballots should always be available at the meeting. At the meeting, you have to have blank ballots and blank envelopes available for people who come to the meeting in person. So yes, I think you would be able to do that. At the annual meeting, what is the percentage of membership necessary to vote on partial or fully funded reserves? The reserve vote is a vote of a majority of a quorum of the membership. We'll talk about that a little bit more later on in the presentation. Okay, let's go back at this point. So board of directors. We talked a little bit about this early on when I tried to sort of put everyone a little bit more at ease. And I mentioned that, if you do the right thing, you act reasonably, you don't get kickbacks, you don't do things for your own personal benefit, you will generally be protected as a director of a not-for-profit corporation, association. The directors have a fiduciary duty to the owners, but that's just to act in the best interest of the corporation and not do those bad acts that I just mentioned. You don't have to get everything right as a board member. You can actually be wrong. You can be a little bit negligent. You just can't be criminal. You can't steal money. You can't act in wanton and willful disregard for the rights or safeties of others. So typically, if you're acting reasonable, you're relying on professional advice, you are complying with your fiduciary duty. I will say that here, the third bullet point, this is very important, particularly if you are a board member or you have a lot of other absent board members. No board member has the right to make unilateral decisions, not the president, no one really. So don't take on too much, really. Don't take on all the business on behalf of your entire board because you want to be nice, because you really might not have authority to do so. So if you're that board member, that lucky board member, you want to make sure that you have that authority, that you've had a board meeting where the majority of the board has delegated certain authorities to you. Maybe you are able to expend less than $1,000 on operational equipment per month without consulting with the board, or maybe you're allowed to hire landscape vendors as delegated to you by the board, but don't make independent decisions because that could get you in some hot water. Conflicts of interest. If you want, as a board member, you're not allowed to personally profit from your position. Sometimes we have board members who want to contract with the association, that they want to be the landscape company, they want to be the accountant, they want to be the consultant on some issue. Well, you know what? The law would authorize that after you jump through some hoops. You're not allowed to be in one of these conflict of interest situations unless you disclose your role to the board, you take yourself out of the board meeting, and 2/3 of the non-interested directors approve of the transaction. If you jump through those hoops and everything is approved, at the next membership meeting, that annual membership meeting or that special membership meeting, then you would have to actually affirmatively disclose the transaction to the members. Say, hey, by the way, Joe Smith, president, he contracted with the association to provide light bulbs. He has a light bulb company. We're getting light bulbs from his company. The 2/3 of the non-interested board members approved this, and now we're disclosing it to you, the members of the association. At that time, the members actually then have the right to vote to cancel the contract, to cancel the arrangement. And if they do, the association cannot owe any type of penalty to that director. We have right here, actually, there used to be somewhat of a conflict in the law in that it provided that a board member or anybody associated with that board member really could not be a service provider to the association. So your president could not be your landscaper or your manager or your pool, service company. But as of July 1 this year, that conflict of interest provision of the law was repealed. So this is no longer part of the law. However, we do still have the provisions that I just mentioned, meaning that if you want to be in an interested transaction, you have to disclose it. You have to remove yourself from the meeting at which it's discussed. 2/3 of the non-interested directors have to approve it, and it has to be disclosed at the membership meeting. So this is we'll see what happens. It was a conflict, so it was hard to work with it. So now at least we know what the procedure is. I will say that. Board of directors, no free lunch. I like this slide. Basically, this is the anti-kickback slide. If you're an officer, director, or manager, you should not be soliciting or offering to get kickbacks for vendors who are get the bid at your property. If you're, I always tell the story that of an HOA, it wasn't really a condo, where the association just entered into a new landscape contract, and lo and behold, the president had all new mulch the next day, and it was provided at no cost by the vendor who was selected. Well, that board member, that was completely improper. You just got a bunch of free mulch. You didn't pay any money for the mulch, and you got it by virtue of being in the role of your HOA president. So that is improper. That is an improper kickback. And that would be a breach of your fiduciary duty. I will say there is no prohibition against officers or directors, managers receiving services in connection with trade shows, educational programs. If you go to a trade show and you win a raffle prize, that's okay, stuff like that. But otherwise, not appropriate. Board member email communication. Whoops, what happened? Okay, back to here. We get questions on this all the time. Can board members vote by email? Well, board members may use email to communicate to one another, but they cannot use email to cast a vote on association matters. So while it's practical, it's realistic, obviously everybody has to communicate by email to set up the stage for your board meeting, you shouldn't use it to circumvent open discussion at meetings. I say that all the time, that you don't just go into your board meeting and have everything pre-planned and have, give the owners no, analysis or consideration regarding the items on the agenda. They should kind of be able to understand how the board came to a conclusion on a certain matter, why they approved something, why they didn't, why they selected a certain vendor. So I would say that while you can use the email, you definitely should continue to have discussion at board meetings and not use it to circumvent all of that. It doesn't look good. It's not a good perception. It always is. It's going to, get the response of that there's not transparency, which we hear all the time in this work. Board meeting notices. I'm shocked that we've got this far into the presentation and we haven't discussed this, except in the case of an emergency. A board meeting requires a 48-hour notice. Again, I keep putting this little asterisk. Make sure you post on the website for condominiums of 150 or more units. People ask all the time, well, what's a board meeting? Is that when we all get around to talk about association business? Is it when we get around to talk about sports? We're all together, we're talking about our kids. Is that a board meeting? Well, let's talk about this a little bit. There's different schools of thoughts here, and I'll start from the more, benign and clearly not a board meeting. I got a question a couple of years ago. I like that they said, we're all meeting at the clubhouse to give out candy for Halloween, and we're going to have more than a quorum of the board there. Is that a board meeting? Well, absolutely not. You're not talking about association business. You're not taking votes. You're not doing anything. If you get together socially to hand out Halloween candy, to talk about sports, to talk about your families, of course, even if there's more than a quorum of the board, that's not a board meeting. When we start getting into some of the, more difficult issues, and there's different schools of thoughts here, seeing different attorneys that you talk to, if you get together with more than a quorum of the board to talk about association business, if you're talking about, that landscape company that you think you want to hire, or the problems that you have with your current landscaper, I personally, in my personal opinion, think that is a board meeting, which notice is required. Some attorneys, think stretch it a little bit farther and they say that's not a board meeting. You're not conducting business. You're not making any decisions. There's nothing on the agenda that you will be determining. So I think both of them have merit, but if you want to be conservative, if you're there with more than a quorum of the board discussing association business, I think that would be a situation where you need to post a notice and have an open board meeting. Sometimes you'll have this like a special topics, not a special board meeting. And I don't want to confuse anyone by saying a special board meeting, but this is where you're talking about special assessments or rules regarding the use of a unit. This is where you need more than a 48-hour notice. This is where you need a 14-day or more notice. This is one of those star page. Please don't forget this, particularly about special assessments. I really can't stress this enough. If you are thinking about adopting a special assessment and you're going to have your vote on it, you need to get this right. You need to send out the notice with the 14 days. You need to set forth the estimated cost and purpose of the assessment, because I always feel bad for those associations who come to me 3 months later when Mary Smith has not paid her assessment that was due on, July 1. And then they say, Allison, can you start collections? And I said, okay, well, the first thing we're going to ask you as Kaye Rembaum or any reputable law firm when you want us to collect a special assessment is send, how did you impose it? Can you send us the backup? Send us the notice, send us the affidavit that you sent, or excuse me, your affidavit of mailing that you really did send this out and post it 14 days in advance. Again, this is a posting thing too, not just sending, send and post. We're going to ask for all of that stuff. We're going to ask for the follow-up letter that you sent saying, hey, by the way, we adopted a special assessment. Here's the due date. Please send the money. If any of that is missing, and I'm really harping on the 14-day notice here, that it could jeopardize your right to collect the assessment. We can't really collect assessments that we know were not properly adopted. So I'm going to say, you know what, unfortunately, you have to go back and you have to reimpose this assessment. You have to go send out another 14-day notice. And now we can't charge interest. We can't charge late fees. We can't really start this process until you do so. So again, I can't stress enough for special assessments that you work with your attorney on this, that you prepare the proper notice, that you hit all of the points that you need so that you don't have a problem collecting on the back end. Board meetings, keep in mind for condo law, they have to have a detailed agenda. You must set forth on the agenda what you plan to talk about. And as we mentioned already, that owners can speak on all agenda items. Board meetings obviously are open most of the time, but there are two situations in which you can have a closed board meeting. Number one, that's when you're meeting with the association lawyer to talk about proposed or pending litigation or threats of legal action, attorney-client privileged matters, or when you're talking about personnel. These are closed meetings. That doesn't mean that you don't need a notice. You still need a notice, but on the notice, you're going to say closed meeting for, legal, closed meeting for personnel, unit owners not, entitled to attend. You are going to still post that notice. And don't fall into the pitfall of using the personnel matter to circumvent, board meetings. Everybody is not personnel. You can't, call a problem owner personnel matter to get around the open meeting requirement. Again, a management company might not be personnel. Management company is a vendor. Whether you could wiggle that into the personnel meeting exemption is to be determined. I know a lot of associations do that, and there is some support for that, I think, and I would try to support that as well. But that's, a little bit gray, I would say. If you have your own employees, you pay people to work for you. That is clearly a personnel matter. If you're talking about disciplinary actions for current employees, you're talking about, potential suspensions, firing, that is an area where it would be proper to have a closed meeting, albeit it must be noticed. At the last bullet point here, we have again the right for the board to adopt rules regarding board meetings, how the owners can speak, when they can speak, how long they can speak, rules regarding, respectful communication. So just like I mentioned for unit owner meetings, I would recommend that you try to adopt these rules for both unit owner and board meetings. If you don't have rules, you can't enforce rules. You can't enforce unwritten rules. So it behooves you to have these things written down in the event you want to enforce them, because then you can actually point to something black and white that says, no, you may not speak on this agenda item. You were required to sign up at the beginning of the meeting and you failed to do so. So I'm sorry, Mrs. Jones, please sit down. It's not your time to speak. If you don't have that rule and you just sort of make it up as you go, it's more difficult, I'll say. We talked about this a little bit already. What is a board meeting? A majority of the board present at a meeting is a quorum. When you have a quorum, that's a board meeting. Can the board attend meetings remotely? Yeah, the statute has said for a really long time that a board member may attend a board meeting by speakerphone, but the people in the audience should be able to hear that board member. I've seen a lot of times where, board member A says board member B is on the phone and board member B is voting a certain way. Yeah, Bob votes yes. Yeah, Bob votes no. That's not okay. We don't know if Bob's really on the phone. We should be able to hear Bob. Bob should be able to hear everybody else, and they should be able to really participate. This has become a little bit more normalized with Zoom and all the remote communication that we've been using, but that is the state of the law. Voting at board meetings, a majority of a quorum of the board makes decisions. No secret ballots at board meetings other than to elect officers. We talked about that. It's not a secret meeting to elect officers. It's a secret vote. When you're taking minutes and you're obviously the secretary, and just as a board, you should know all of your votes have to be made in public. You have to write down in your minute how each person votes specifically. You shouldn't just say 3 against, 2 yes. You have to say who voted for what and in which way. Mary, yes. Chad, no. Allison, yes. So make sure you have your minutes in that manner, or else it's very difficult to follow. Committee meetings, this is somewhat like of a more obscure, lesser known rule that I feel that, a lot of people may not really follow, but this is part of the Florida Condominium Act, that committee meetings actually be noticed and open in the same manner as board meetings. You have to have a 48-hour notice and it has to be open. There are some exceptions here. If provided in your bylaws, meetings of committees don't have to be noticed or they don't have to be open. So some of my associations have made these amendments to the bylaws to say, our decorating committee doesn't have to be open, our, personnel committee doesn't have to be open. Of course, it's a personnel meeting, but some of these other committees that aren't that critical, do they really have to be noticed and opened? Maybe they shouldn't. But even if your bylaws provide for that exemption, there are 2 committees that always have to have a notice and be open to unit owners. That is where they're making recommendations to the board regarding the budget and when they're taking final action on behalf of the board. I would always say that committees should be advisory, that they shouldn't take final action on behalf of the board. So number 1 should probably be off the table. But when you have the finance committee, capital improvement committee, budget committee, and they're making recommendations to the board regarding the budget, that is always a 48-hour noticed and open meeting. Okay, so I've shared all of that with you this far, and I have to be quite honest with you. We only have maybe 30 minutes left, and we're on slide 61 of 117. This is a lot of material to get through, and as you can tell, I'm trying to speak pretty quickly, and we'll try to move through the material, but let me check the questions to see if we have anything pertinent. Fernando, does an advisory committee meeting must be noticed? Yes, unless your bylaws exempt them from notice. That's the state of the law there. How do you get off the board? Well, you can resign in writing. And I will say that some board members too hastily do this. As soon as you resign, you say, I resign, and you write an email and you send it to your board members, there are no takebacks. You can't just take back your resignation. You are off the board. So think very carefully before you resign in writing, because once you resign, you're off. And as I mentioned, the remaining board members get to fill a replacement, and they might not put you back on the board. I've had that happen many times where somebody too hastily sends that email because they're upset about a certain matter. And then they say, you know what? I regret that. I said that too quickly. Please appoint me back to the board. And the board says, you know what? No, we don't want you anymore. We're not appointing you back. You could get off the board by a recall. This is where a majority of the entire membership basically has petitioned to have you removed. You become delinquent in the payment of any monetary obligation for more than 90 days. You're off the board and they do not have to put you back on. I will say that I mentioned that the language in the statute changed regarding eligibility to get on the board. You can only assessments are considered regarding eligibility to get on the board now, but they didn't change the rest of the statute here. To get off the board, you can be delinquent in any payment of monetary obligation. So if you have a fine, you got on the board, but then you had a fine and you didn't pay it for more than 90 days, you're deemed to have abandoned your office, creating a vacancy. Criminal charges are issued against you for theft or embezzlement of the association's funds. You're off the board. If you knowingly and willfully violate the Florida Condominium Act and the division says that you did something and removes you, you're off the board. If you fail to satisfy this board certification requirement that we're here for today, you're temporarily suspended from the board, not totally removed. Or number 7, this is very interesting. If the board finds that an officer or director has violated a conflict of interest issue, that they improperly entered into a transaction with themselves, something like that, they're deemed abandoned from their office. So that is on the other board members to sort of make that demand and push them out. But that is, I think, one of the latest and greatest additions to the statute regarding how to get off the board. Keep in mind, we have here now in the Florida Condominium Act, criminal penalties for various different things, improper acts, forging a ballot envelope, destroying financial records, not allowing access to records with some kind of criminal intent. These are all now expressly in the statute as criminal penalties. I think they always were, but after some activity that occurred a few years ago, I believe down in Miami-Dade, we had some legislatures who wanted to beef up the Condo Act to actually expressly address some of these bad acts in black and white as crimes. So you'll see if you read through Chapter 718, you will find that it does include these acts as these bad acts, and sets forth in black and white that you will be subject to criminal penalties and investigations if you do some of these things. Meeting minutes. I talk about this quite often in that meeting minutes should be minutes. They should not be transcriptions of your entire meeting. That is improper. It might cause liability to your association. It's very difficult out there because you want to be transparent. You want to advise the owners of what's going on in the condo. You want to keep them updated, but you also have to think about, as board members, some of the stuff is just too much for being in minutes. If somebody else gets their hands on these minutes, they could take these things out of context and they could use them against you. If you had, a meeting where you talk about, a leak in the roof and that, you had water and that you're searching for vendors, and then maybe the next week, and you go through a whole discussion on it and you let owners give statements and you put all this commentary in the minutes, and then maybe next month somebody has an accident and there's a lawsuit, and now these minutes are the subject of the lawsuit, and the owner's lawyer is taking them out of context and asserting all different kinds of different crazy allegations based off of these minutes. It's just a bad situation. You want to keep them brief. You want to keep them to motions, discussion was had, and then the votes of the board, and keep them as brief as possible. I'm telling you right now, many situations behoove you to limit your minutes in this regard. Access to units is our next discussion point, and because I'm moving not as quickly as I had hoped, I'm sorry, I'm going to have to limit some of the questions so we can try to get through more of this material. If you don't know, please know that you have the irrevocable right of access to each unit during reasonable hours when necessary for maintenance, repairs, or replacements, or when necessary to prevent damage. If you see water rushing out of the door of a unit, please get into that unit. You can go hire a locksmith and get in if you see something of that nature. But keep in mind that in the statute, it uses the term necessary. It has to be necessary. There's a famous case out there that the association asserted that it needed to get into a unit. It was necessary to get in there for pest control. Well, the owner objected to it. The owner said that it was not necessary. There was no evidence of vermin, pests, that they'd never have any evidence of it. And they fought this association. They went up to a district court of appeals, and the appeals court determined that it had to be a necessary access. And because the association could not substantiate the necessary need for this pest control access, they were not allowed in. So keep that in mind. It's not just you get to go in whenever you want for whenever you want, or you want to go in to inspect. This is not a right of inspection. It's a right of necessary access. You do have enhanced access to abandoned units. There's a statutory definition of abandoned units. Nobody's lived there. You have to send notice out 2 days, then you can get in and you can actually do these inspections that I said were not otherwise allowed. And you can try to secure the unit. If there's no AC, maybe you have to clean out a refrigerator. You have cost incurred in doing this that you can charge to that owner, and it's secured by a lien. Rules and regulations. I talked about this like way at the beginning of the course, and I said they weren't even on the page because they were less important than the declaration, articles, and bylaws. Well, I emphasize that now and go through this pretty quickly, that rules and regulations adopted by the board must, the first element here is they have to be reasonable. They have to be for a health, safety, or welfare objective. If you can't substantiate that therefore health, safety, or welfare, then they're not going to be reasonable. And reasonable is subjective, and courts determine that at the end of the day. But the more critical thing that I see all the time is they cannot circumvent or contravene express provisions of your governing documents or rights implied by your governing documents. So sort of the most notorious improper, invalid rule here in condos are leasing restrictions. Leasing restrictions really should not be in your board-made rules. They could be valid in certain cases, but that's not the typical. Leasing restrictions, typically speaking, must be in your declaration because they would contravene rights implied by the declaration, and the case law supports that. So I guess the takeaway in the rule slide is that when you're imposing new rules and you want them to be enforceable, you better be sure that they don't contravene your declaration. If you're concerned about these rules, that you think you might be sort of imposing rules that are questionable, this is one that you want to talk to your lawyer about, have them do a rule review to make sure that the rules are enforceable, and then you can actually hold them up. The future of remote meetings. I put this in a while ago last year during emergency powers, where we had Zoom meetings basically authorized under the emergency power law. They were authorized in whole or in part during the period where emergency powers were authorized. That's when we're under a state of emergency issued by the governor, and we're allowed to use the statutory emergency powers. Once the emergency powers are no longer in effect, I am of the opinion that using Zoom, using remote meetings can be an option. They can be in addition to physical attendance, that you can't impose that everybody continue to use Zoom and not provide an option to go to a physical location when we're not under emergency powers. This is becoming very difficult right now during our COVID resurgence, because we all know that we're not under an emergency order by the governor anymore, but now we have a lot more cases. Apparently the hospitals are quite overrun at this point. So can you require that everybody attend a meeting via Zoom and prohibit physical attendance? Probably not under the state of the law. You might take your chances with that if you feel that that is for the best health, safety, welfare of the owners. But under the current law, it would be difficult to deal with not providing an option for people to attend. And whether that's, a room that's limited to maybe the first 20 people that get there, because that's that's the amount of people that could fit reasonably in that room. Maybe you require physical attendance to be, masks only. There's certain reasonable restrictions that you could put on the physical attendance, but I'm just not so sure sitting here today that we can say you would only attend a meeting by Zoom. I'm just not so sure about that. I'm on this task force evaluating issues resulting from, the collapse, and I've also served on a task force for the COVID situation, and this is definitely an area where there's emerging issues. I would hope and suspect that we would see some statutory updates in the next couple years addressing these matters, but we're not going to see any changes very quickly, tomorrow, this year, next year. But I think that we will see this in the future, and maybe have more options. We hear arguments, attending via Zoom is physical attendance. We can all see each other, and there are arguments to be made there, but I can't say here today that it would be okay. There are procedures to authorize owners to participate and vote on remote meetings, Zoom meetings. They're under Chapter 617, that Florida Not-for-Profit Corporate Act I talked about a while ago. You can look at this if you would like to. That's slide 70. I have some best practices in here for remote meetings. Basically, it's sort of manage expectations, tell owners how the meeting is going to go down, try to limit the agenda for that remote meeting possibly, because it's very difficult to go back and forth and let people speak when you have hundreds and thousands of owners on a Zoom meeting. You might ask people to submit their questions in advance. Yes, we all know that members have the right to attend and speak on every agenda item, but that doesn't mean that you can't request that they put their questions in writing if possible, and encourage them to send them in advance rather than, maneuver the Zoom on the spot. It's much easier. It provides for a better flow. So that could be helpful. Always keep in mind, as I've been mentioning, that I think at this time here today that a physical location would probably be required. So if you have a membership meeting, make sure that you have proxy and ballot forms available at that physical location, not only the ones sent out in advance. I think this might be one of the last topics we cover: use rights and suspension on voting rights. You can fine and suspend voting rights for non-monetary obligations. This is where, I'm sorry, somebody paints their door pink and that was improper. You can fine them and you can suspend their right to use the facilities. That would require a hearing before a compliance committee, fining committee, grievance committee. They all, we hear different names for these things, but you have to send a 14-day notice, and the committee must approve or reject the fine or suspension. If the committee does not approve the fine, approve the suspension, it shall not be made. Fines are $100 maximum per violation and $1,000 in the aggregate for a continuing violation. In a condominium association, fines cannot become a lien against a unit. In a homeowners association, fines of $1,000 or more can become a lien. There is just simply no liens for fines in condos. So my clients always ask, well, what's what are fines worth then? You know, sometimes we have associations that are pretty good at collecting these fines. Maybe they even take these owners to small claims court themselves to collect, or they just sort of forget about it. But in condos, they don't have as much teeth as in HOAs. You can also have your use rates suspended, your key fob deactivated for failing to pay a monetary obligation for more than 90 days. This does not require a 14-day notice. This requires a board meeting with a 48-hour notice anyway. I will say that the board must somehow specifically delineate the persons suspended at each meeting. You cannot have like a blanket policy that says, you know, you have one board meeting that said anybody more than 90 days delinquent will have their use rate suspended. No, it doesn't work going forward. You have to have this as a standing agenda item at every meeting, and you have to suspend specifically the people who are more than 90 days, and you have to either note their names or unit numbers in the minutes of those meetings. Use rate suspensions, they don't apply to parking spaces. You can't prevent somebody from getting into the building. You can't prevent somebody from getting utility service, so don't try that. Voting suspensions for people more than 90 days delinquent and a greater than $1,000, you can suspend voting rights. You have to jump through some hoops, but I will mention the first bullet point. We had a new case come out maybe 2 to 3 months ago that said, this is a no-no. They said you can't suspend people's votes. Voting is a very special right in condos, so the statute cannot be retroactively used against owners in associations. And if you want to suspend votes, your documents must authorize it, or your documents must have the magic Kaufman language that provides that the new statutes are automatically incorporated into your documents. So this is, I'm going very quickly and this is oversimplified, but if you want to suspend votes, if you have suspended votes in the past, this is something that you need to take a re-look at. Star this page because you might not really have the authority to do so under this new case. It's something that you need to very carefully take a look at. Official records. We all know that you have to have all of your records open to owners. They're mainly kept for 7 years. The plans, the declaration, articles, bylaws, and meeting minutes must be kept permanently as of, I believe, 2018. The new change in the law, just as of this year, bids must be kept from 1 year. Records not accessible to owners, most important, attorney-client privilege documents. If I write you an opinion letter concerning, you know, this letter responds to your request for an opinion regarding who's responsible to maintain windows, that's attorney-client privilege. That letter does not go to the owners. If I wrote, you know, a demand letter to somebody to, for a, you know, some kind of, you painted your door pink, please change it back to black, and some other owner asks for a copy of that, that could be a letter that you give to the owner. You cannot give out medical information. Somebody submitted some request for an emotional support animal and they've given you doctor's letters. Those are not accessible. Personal identifying information regarding owners, social security numbers, past places of residence, reference information, that is not accessible to owners. If an owner wants to allow you to give their email address out, they can consent to the disclosure of the email, but email addresses are not accessible to other owners unless they've opted in to receive notice of meetings via email. But I talked about that way earlier on. If you consent to receive notice via email, that email address that you provide becomes part of the official records. Here we have attorney-client privilege, you cannot disclose. Records requests, access must be provided within 10 working days after receipt by the board. Renters now have the authority to inspect and copy declaration, bylaws, and rules. And I'm just jumping around really quickly here that you do have the authority to make reasonable rules regarding frequency, timing, locations, notice, and manner of records inspection. Please carefully work with your attorney if you want to have rules regarding records inspections. Again, these are reasonable rules that can't totally vitiate their right to get records, which is a pretty critical right. You know, I hear a lot resulting from Champlain, the collapse issues, that owners and really third parties a lot of times want to get their hands on engineering reports and want to be assured that the association has done their due diligence as to certain projects. So you can put reasonable rules on them, but they are allowed to get it one way or the other. There are penalties for not complying with these records requests. There's statutory damages not to exceed $500 and any actual damages incurred. You can have unit owner directories with telephone numbers, no email addresses. We went over that a little bit. Associations of 150 or more units have to have a website. The new law effective July 1 this year also allows for apps, not only websites, but now you can have apps. Other than that, there are no changes. And if you have a condo of 150 units or more, please carefully look at these requirements. Most importantly, in my opinion, is that you have to post the notices of meetings to the websites, and any budgets have to be posted to the websites. Agreements have to be posted to the websites. So please take a closer look at this if you're within that requirement. Contracts must be in writing. You have to get bids when a contract exceeds 5% of your total annual budget, including reserves. There are some exceptions for contracts with professional service vendors, such as attorneys, architects, engineers. You don't need bids for those type of services. Insurance, a lot of insurance issues. We could have a whole class on insurance. You must have fidelity bonding for those who control your funds. I will point out that you have to have property insurance covering all portions of the condominium property, other than the portions that are required to be insured by unit owners: floor coverings, wall coverings, appliances, blinds, hardware. Very few items are covered by owners, and the 90% of the condo property, drywall, windows, doors, sliding glass doors, all of that is going to be covered by the association most often times. I will point out, which I think is very interesting, that the association by statute doesn't have to maintain liability insurance. It's optional. Liability, D&O insurance, flood insurance is not required by law, but it's highly recommended. If you don't have liability insurance, that's a huge problem. And I would suspect that your declaration may require it anyway, whether the statute does or not. And I would suspect that we will see some statutory amendments following the collapse issues, possibly, that now would require more insurance from associations. Not sure we're going to see specific coverage levels required, but I would suspect that maybe the statute is going to be changed on this optional insurance. The budget section, I feel, is very important, and I'm disappointed we did not get to speak about this in more detail. I want to mention the new change in the law as of July 1, 2021. The budget must be adopted not less than 14 days before the end of the fiscal year. This means you can't wait till next year to approve your budget. People need to know what the assessment amounts are. So this law was now put into place. There is sort of a saving here, where if you fail to do so, your prior budget will roll over, and it will only be considered a minor violation by the division. Some of these violations are quite hefty, $5,000 fines. So this is not something that you want to get into. You want to adopt it no less than 14 days before. Please keep in mind that the decision to budget for reserves is with the board. The board has to budget for reserves. They have to budget for painting, paving, and roofing, and anything else for which the replacement cost exceeds $10,000. That is a requirement that the budget contain fully funded reserves. The board can then propose to the owners, if the board shall choose, that the owners may potentially either waive reserves, they might put out a waiver, total waiver, or they might put out maybe a partial waiver, so they partially fund the reserves at a certain level. But the board can determine not to put that vote out to the owners, and the board can determine to just frankly fully fund reserves. And I will say, and we're probably going to leave on this note, that in light of Surfside and many issues being evaluated, I would probably tell you that we might see some changes in reserves. Are we going to be able to waive every year in perpetuity? Are we going to be able to, maybe we have the option to partially fund, but I'm not so sure. We'll see. These are all emerging issues that will be the subject of future legislation. And of course, we will keep you highly updated here at Kaye Rembaum. But I foresee we will potentially have some reserve changes. Maybe we'll have a requirement that they be funded always. Maybe we will have that. Maybe you can't waive for more than 3 years in a row. Maybe you'll have to keep them funded at a certain level. Maybe we will have a requirement that you have a reserve study performed every so often, every couple years. I can't tell I don't know. I'm not have a crystal ball here, but I'm privy to, a lot of information to intelligently tell you that these are issues that are coming. So if you have zero reserves, or if you've never had a reserve study, I would start thinking about, looking into that. This is an issue that's, very important. You have to have money to operate your condo. You have to be able to fund these projects as they come up, and special assessments, aren't there that quickly. You don't get the money overnight. So I will say that reserves are very important. Don't blow them off. If you've not had a reserve study, I would recommend that you think about getting one, and you put in some short-term and long-term reserve funds. You think about reserves in a different way than maybe you had in the past. That's how I'll put it. If you want to continue waiving or reducing, the vote is a majority of a quorum for as long as you'll be able to do that. Keep in mind, these are restricted reserves. You can't use reserves for your roof for painting. You can't use your painting reserve for new furniture unless you get the prior approval of a majority of a quorum of the membership. If you continue to ask your owners to waive or reduce reserves, you are required to have a disclaimer on your proxy form. This is the disclaimer that you have to use. If you don't include this disclaimer, you will be cited by the division. So this is something easy. You don't want to fall into that pitfall. And I know we are over the time limit, and many of you have stuck out this entire course. Thank you very, very much. We have very few slides left. I'm happy to say we have some slides on financial reporting, levels of financial reporting, whether you have to have an audit, a review. So check out those slides as we get to the end here. And I appreciate you sticking with me today. Thank you very much. And email me if you have any questions that I could answer. Again, not detailed fact situations from your association, but if you have general questions, feel free to do so. If your association is looking for new counsel, of course, I'm here. Please reach out. And thank you very much, everyone. Have a great evening. And I'm looking forward to seeing you in my next course, which will likely be elections in the next few months. And we'll also have the legal update course on our website to be given in the next few months as well. Thank you so much. Jeff, anything further?